Welcome to today's program, In Bitcoin We Trust, Avoiding Administrative Pitfalls in Trusts and Estates with Large Concentrations of Crypto and Other Digital Assets. We are thrilled to have you join us today. My name is Jacqueline Yu, and I'm the co-chair of the Beverly Hills Bar Association's Trust and Estates section. Before we begin, I'd like to take a moment to introduce Brian Joy of the Sanborn team. The Sanborn team has been the official sponsor of this section since 2006. Brian, please say hello.
Hi, thank you, Jacqueline. I just want to take a moment to reintroduce the Sanborn team to everyone. We have over 40 years of experience specializing in probate and trust real estate sales. While we're based in Beverly Hills, we represent properties throughout California, as well as other states, thanks to our trusted network of agents within the Berkshire Hathaway Probate and Trust Division. Just last week, we closed a property in Coronado Island in San Diego. And this week, we're listing farmland in Utah. Whatever the scenario or location, we're confident we could help you and your clients. Thank you, everyone. I'm looking forward to JD's presentation.
Thank you, Brian. In addition to the Sanborn team, the Trust and Estates section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Rochelle Schultz to provide this month's legal updates.
Thanks so much. Good afternoon. Today I will be presenting the case of Heron versus George S. This case involved a wealthy 86-year-old man with severe dementia and visual impairment named George. George had two daughters, Susanna and Gabriella. After two doctors determined that George lacked capacity to make financial decisions, Gabriella contacted a trust and estate attorney and arranged to have the attorney meet with George privately. The attorney met with George alone at his house for over an hour after insisting that his caregivers leave them alone. At the meeting, George signed the attorney's fee agreement requiring a $100,000 retainer after the attorney told George where to sign. At the time, the attorney knew George's vision was impaired and that two doctors had determined George lacked capacity. The same day, the attorney sent a letter for payment of the retainer to the trustees of George's trust. Susanna, as George's attorney in fact, filed a request for an elder abuse restraining order against the attorney, and the attorney objected. After a lengthy evidentiary hearing, the trial court issued a restraining order against the attorney after finding that the attorney committed financial elder abuse, because the attorney exerted undue influence to obtain a property right from George, namely an agreement to pay a $100,000 retainer. And the attorney knew or should have known that the attorney's conduct would be harmful to George. The attorney appealed on several grounds, including that the trial court could not issue the restraining order without first determining George's capacity, and that there was no substantial evidence that she committed financial elder abuse. The appellate court affirmed the restraining order, concluding that an elder abuse restraining order may issue without determination of the elder's capacity. The attorney's fee agreement is a property right, and there was substantial evidence that the attorney committed financial elder abuse by exerting undue influence to obtain that property right from George. I hope you enjoy the program.
Thanks, Rochelle. Now on to the program. It's my pleasure to introduce today's speaker, JD Reese. JD is special counsel in the Business Trial Practice Group of Shepard Mullin Century City Office. His practice focuses primarily on trust and estates litigation and administration. JD litigates all manner of probate court disputes, including trust and will contests, heirship disputes, fiduciary removal and surcharge actions, elder abuse actions, contested conservatorships and guardianships, and more. JD also practices in civil court regularly, both in probate and in general commercial matters. In addition to litigating matters through mediation and trial, JD advises his individual, institutional, and nonprofit clients on adverse administrations of trusts and estates with assets that span the globe. Additionally, for the past several years, JD has helped clients in drafting and revising their estate plans. Thanks, JD. We're really looking forward to your presentation today.
Thank you, Teal. Thank you so much, everyone, for being here today. And thank you also to the Beverly Hills Bar Association's Trust and Estates Law section for inviting me to be here with you all today. It's an honor to get to speak with such an esteemed group of lawyers on a topic that I'm passionate about, which is the intersection of trusts, estates, and digital assets like cryptocurrencies. Before we get into it, I'll share a little bit about myself. A lot of it was covered in that very generous introduction by Teal. Thank you. I will say that I have represented clients, in addition to speaking and presenting on this topic, I've represented clients who have dealt with considerable concentrations of trusts, of digital assets within trusts and within estates, all kinds of complex issues involved with marshaling, administering, and distributing those assets. So I don't just talk about it, I've also walked the walk here a little bit, and I'm thoroughly excited to get to be here with you. If you'd like to check out more information about me, my contact information, LinkedIn are there. But with that, let's get into what we're really here to talk about today. So before we get started, I'd like to...
You need to share the slides, sorry.
Oh, thank you so much. Sorry, I forgot to start my slideshow. Thank you. There we go. Okay, there is my contact information. This will also be there at the end, so no worries. Let's start today with a short story about an American businessman named Matthew Mellon. Mr. Mellon was the heir to the Mellon Bank fortune, and famously, about a decade and a half ago, Mr. Mellon turned a $2 million investment in cryptocurrency into more than $1 billion investment. Sadly, Mr. Mellon passed away suddenly and unexpectedly at the age of 54 in April 2018. Now, April 2018 was an interesting time in the crypto space for those who were following it. Let's look first at a chart showing the price of Bitcoin in April 2018. And we're looking at Bitcoin first because at the time, Bitcoin was a really strong indicator for how the overall crypto market was performing. Now, as you can see here in April 2018, that was that red arrow on the right side of the screen. That was about 4 months after Bitcoin had peaked at its then all-time high value of more than $20,000 per Bitcoin. But 4 months later, when Mr. Mellon died on April 16th, the value of Bitcoin had plummeted to less than $8,000 each. So a 60% decrease in value in just 4 months of time. And the volatility was just beginning. According to some pro beta filings in the estate of Mr. Mellon, the holdings of his estate cryptocurrency continued to fluctuate an additional 30% from their date of death value in just a matter of a couple of weeks after his death. Now, this is a chart for Bitcoin, but what about the crypto that made up the large bulk of the assets of Mr. Mellon's estate? In April 2018, Mr. Mellon had most of his assets were in a crypto called Ripple. In 4 months prior to his death, the average price of Ripple was trading at more than $4 each. But then 4 months later, in April 2018, they were trading for 65 cents each. So Ripple had lost 83% of its value in just a few months before Mr. Mellon passed away. So the administrator-to-be was walking into a situation here where the value of estate assets wasn't just theoretically risky or potentially problematic. It was actually plunging again and again over a matter of weeks and days, some cases hours. So legitimately terrifying stuff from the perspective of a fiduciary or their counsel who might be responsible. And just to make sure this case truly reads like a law school final exam hypo, let's flag a few additional complications that Mr. Mellon left behind. When he died, he had 2 ex-wives, 3 children among them, and a long-term girlfriend. He was in the process of changing domiciles from one U.S. state to another before he happened to die abroad in a foreign country. According to an accounting filed in the estate of Mr. Mellon, it's not just that he had a lot of crypto. More than 97% of the value of his estate was invested in a single cryptocurrency, Ripple. Mr. Mellon also had millions of dollars worth of business and real estate interests that went across the country. And the last time he executed a will, of course, was 5 years before his death, when he was still married to an ex-wife, and when most states, including California, where he was domiciled, had no laws on the books regarding digital assets. So just imagine for a moment, a couple other complications there, no tax returns. I mean, just the worst kind of situation to be walking into. Imagine you're named as the personal representative, or a potential client comes to you and says that they've been named as the personal representative of their ex-husband's estate that had at one point more than $1 billion of crypto. How confident are we that we could help navigate that administration without reasonable prospects of liability? Or imagine that a client comes to you now and says that they are currently the trustee of a trust with over several $1 million of crypto. How would we begin to advise that trustee? that brings us to the theme of today's talk, which has two parts. First, things in the blockchain and cryptocurrency space are moving quickly, technologically, economically, a little more slowly, legally. So keeping in mind that this is a space that's constantly evolving, I want to help orient you so we know which way is north, and so that when a client comes to us with crypto estate planning or admin or litigation questions, that we can start to help them spot and work through issues. Today's talk is not about whether cryptocurrencies are sound investments. It's about starting to put together the building blocks so we can be a resource for our clients and either help them or find someone who can after we spot some of these issues. So today's talk is about being prepared. With that in mind, here's a brief overview of the main topics we're going to cover today before we take some questions. First, we'll talk about blockchain and crypto basics. So before we get into the law, we'll speak briefly about what these technologies are and why it's important that we even care about them in the first place. Second, we'll review how folks are investing in blockchain and cryptocurrencies. This will help us understand from an estate planning standpoint, how might these assets even come to be in a trust or estate? Third, we'll go over some high-level estate planning and administration issues, things like how to access a person's crypto post-death, keeping assets safe during administration, and also some vital tax considerations as well. Fourth, we will touch on how California's web of fiduciary duties apply in the context of cryptocurrencies. And then fifth and finally, we'll try to close out by answering some of your questions. So with that, let's turn to our first topic, which is blockchain and crypto basics. What are blockchains and cryptocurrencies? Before we get into that, a quick disclaimer, I don't want to give the false impression that all blockchains and all cryptos are identical or even highly similar, or that they all use the same technology, because in truth, there are nuances among blockchains and the types of protocols they use, the types of securities that they utilize, which in turn affect their respective risks and benefits. So for instance, whether a blockchain is open or private, whether it uses proof of stake or proof of work or some other consensus method, these are different axes on which a cryptocurrency or a blockchain asset might differ among another blockchain or crypto asset. So keeping in mind that it's impossible to give a universal definition that is perfectly accurate for all cryptos, let's look at some of the common features that are becoming defining among this type of asset. So at its core, a blockchain is basically just a digital ledger of information. Electronic record books that keep track of certain kinds of transactions like sales of goods, transfers of ownership of a parcel of real property, or steps in a supply chain. So, for example, in the same way that a county recorder's office maintains a ledger of all transactions affecting certain pieces of real property, or in the way that Venmo keeps track of all the debits and credits on your account, blockchains are fundamentally just ledgers of transactions. So blockchain technology isn't really unique in terms of what it does. Instead, what makes blockchain technology unique is how it does what it does. And when done right, blockchains are decentralized or known as distributed. And what that means is that instead of a single master ledger being stored on a single central database at a single location with a single point of failure, blockchain ledgers exist and are maintained across a peer-to-peer network of computers. And each computer or node in that network maintains its own independent copy of the ledger. And the nodes in the network only update their individual ledgers with new transactions once a critical mass of the other nodes in them agree that the new transactions to be added are legitimate. So I don't want to get too bogged down in the details of how new transactions are verified as legitimate. It is absolutely fascinating, but it's not really vital for today's conversation. The important thing to take away about this conceptually is that this approach of decentralizing the ledger across multiple points of failure is arguably the defining feature of blockchain technology. Decentralization also leads blockchains to have several other attributes. Perhaps most fundamentally, they are designed to be so inherently resistant to fraud that probabilistically, it's just not even worth trying it. So it'd be like trying to crack a safe that has a code that is 100 digits long. You don't have any idea what that code is. And oh, by the way, that code changes every 5 minutes or so. So sure, theoretically, if you spend long enough trying to crack that safe, you might stumble into the right answer, but the probability of any one guess being right is so infinitesimally small that it's just not even worth trying. And blockchains essentially accomplish this with computer science and cryptography, and by leveraging an entire network of computers that are competing against one another and checking one another's work. Because blockchain technologies are so resistant to fraud, they are said to be trustless. You don't really need to trust or know anything about a person who is sending you Bitcoin for you to have reasonable certainty that the Bitcoin they're sending you is legitimate. Because the chances that they cheated and created fake Bitcoin to send you is so small that it's not really worth holding your breath for that possibility. Because blockchain transactions are maintained by computers, they are relatively instantaneous. Some blockchains confirm new transactions every few seconds. Bitcoin does a new block of transactions every 10 minutes or so. Compare that to how long it might take someone in Los Angeles to wire a big amount of money to someone in rural Asia or Africa. Admittedly, this might not seem like a huge deal to Western folks like us who are used to settling transactions instantly with credit cards and with Zelle and Venmo. But for international businesses that are settling enormous transactions, or for the estimated 20% of the world's population that are unbanked and don't have access to rapid settlement of transactions, the speed and reach of blockchain technologies is really transformative for them in a financial standpoint. Finally, blockchains are said to be resistant to censorship or neutral, essentially because blockchains are decentralized and no single authority can direct how those blockchains are to proceed. That means there's no central authority that can censor or stop certain people from transacting. Contrast that with here in the US, where if you get a court order, a bank account can be frozen, or certain assets in foreign countries might be subject to freezing or forfeiture based on illegitimate government attempts to control citizens. Obviously not something we're used to dealing with here in the States, but thinking about the broader public of the world, why they care, censorship resistance is actually a pretty important feature. There are several other distinguishing factors for blockchains. They can be public or private, permissioned or permissionless. They can reach consensus in a variety of different ways. I could talk all day about these things, but I want to use our valuable time a little bit more focused on the T&E stuff. But really, I just want to show this again to highlight the fact that not all cryptos are the same. Not all blockchains are the same. So we've talked a little bit about what blockchain technologies are. What about cryptocurrencies? In short, cryptocurrencies are applications or programs that use blockchain technology and allow for trading of tokens. So blockchains are the underlying technology or platform that enables the use of a cryptocurrency. Just like you couldn't use email before someone invented the internet, cryptocurrencies weren't really possible before the advent of blockchain technology. Now, cryptocurrency tokens that people trade can do various things. Sometimes they're just units of currency like Bitcoin or Bitcoin Cash, but there are some cryptocurrencies that have more advanced features. They may represent ownership interests in companies or other going concerns, which may or may not be blockchain related. Some tokens permit voting or participation in other kinds of network or company-wide decisions. Some cryptocurrencies even allow and support what are known as smart contracts, which are self-executing digital contracts written into blockchains like the Ethereum blockchain, which is the second most popular blockchain in existence right now. By way of demonstration, this is sort of how a typical Bitcoin transaction works. Let's say I want to send my friend Billy a Bitcoin. So I go to my computer, log into my wallet, I enter in Billy's public address and how much Bitcoin I want to send. Then I click the send button. That proposed transaction is then broadcast across the Bitcoin network in a gossip-like way. Over time, nodes in the network that validate these transactions, they're called miners, verify that I am who I say I am, I have a Bitcoin to give, and the address that I'm sending it to is legitimate. Over time, once a critical mass of those miners authenticate my transaction as valid, it eventually gets batched up into what's known as a block or a group of other transactions. And then over time, those blocks are added to the chain of pre-existing historical blockchain transactions. And so after that happens, Billy receives his blockchain, his Bitcoin that I transferred to him, and he is able to spend it and use it how he sees fit. It's out of my possession. I can no longer control it. That's typically how this works. So why should we care about blockchain and crypto? Why should anyone care, right? Isn't this just the next fad like Pogs in the 1980s or Teeny Beanie Babies in the 90s or tulips in the mid 1600s Holland, for those of the history fans out there? Rather than try to convince people or explain the various hypothetical and actual use cases for thousands of cryptos and blockchain technologies, let's do something different. Let's just look at some data for a moment. So adoption is a key metric that tells us whether a user base for some new technology is growing. One way to look at the number is to look at the number of people and entities, new people over time coming into the use of this technology, the growth. And these graphs show the number of users over time on the 3 largest crypto exchanges operating in the US: Coinbase, Binance, and Kraken. I had trouble finding clean versions of these graphs extending into the last year, so I recognize they're a year outdated, but these are well in line with what we've seen over the last year and a half. So over time, we're seeing, the last decade or so, steady, consistent growth in the adoption by users and institutions of blockchain and cryptocurrencies. And this data is also consistent with what we're seeing worldwide as well, which is a growth, steady and consistent growth by users, rich and poor, in countries large and small. Another metric we can look at is what's known as on-chain metrics. And this one in particular is the number of transactions per day. And when we look at the volume of Bitcoin transactions today, which is what we see in this chart here, we see, for instance, that, again, the growth over time in the number of transactions that this network is supporting is significant. And although we are not quite as high as we were at the end of last year in terms of daily transactions, we're still hovering between 300 and 500,000 Bitcoin transactions being confirmed per day, which is, remarkable. Ethereum, the number two cryptocurrency by market cap, looks similar and in fact has remained relatively steady since it shot up in 2021. It's less susceptible to the whims of the market. A lot of transactions, a lot of business is being done on the Ethereum network right now, in part because it is supportive of these smart contracts. As of today, I think there are about 1.3 million transactions on the Ethereum network per day, which is up about 15% from a year ago. Here's another graph that shows the market capitalization, or the market cap, of all cryptos. So all cryptos in existence multiplied by their respective value and then aggregated. And this graph shows us that we eclipsed $2 trillion last year and that we've been in the $3 trillion market cap range for most of this year. So as of today, Bitcoin is the 6th largest asset in the world by market cap, coming in just after Microsoft, Apple, and Amazon, and right before Alphabet, Google, and Silver. Now, why do these graphs show us that we should care? I would submit that they show us that these are not just fads like Pogs and Teeny Beanie Babies. These aren't assets that have a meteoric rise in popularity and then plummet to non-existence shortly thereafter. Instead, we're noticing that these assets have some staying power and that they, over the course of the last decade and a half now, not all of them, but many of them have hung around. And so maybe they're not going away anytime soon. And as a result of that, maybe we should be familiarized with what these things are to some degree so that we're not caught totally flat-footed. And specifically, why should trusts and estates and fiduciaries care about this kind of stuff? Attorneys and the fiduciaries that we represent. I'll go back to that graph from a few minutes ago, which shows that the number of users over time on major crypto exchanges in the US is growing. And so the bottom line is that whether or not we think these are sound investments, we are seeing an increased likelihood that decedents in the US and in California are going to have some amount of cryptocurrency in their estate or trust. And so that, as a result of that, it's our responsibility as the attorneys and folks guiding the administration of these trusts and estates to be familiar with these things. So quick recap, blockchains or blockchain technology are just digital decentralized ledgers of information. Cryptocurrencies are tokens that can be traded and that use leverage blockchain technology. And finally, adoption is increasing, so we want to be prepared. We've talked a little bit about what blockchain and crypto are and why we should care. So let's talk now about the ways in which these digital assets might appear in someone's estates. Although most of us are familiar with the concept of buying and selling directly, that's not really the only way that we're seeing folks investing in these things. So first and foremost, of course, is the people going and buying and selling cryptos directly on exchanges. These are online websites where you can buy, sell, trade, and transfer crypto using all kinds of fiat currency like US dollars, euros, and other things to fund those purchases. This is a screenshot of what Coinbase looked like several years ago. In fact, you can see I proposed to a fake transaction. One Bitcoin at the time was trading for $4,201. I think as of today, it was like $117,000 per. I don't think I made this purchase here, but this shows you what it looks like. In the same way that you might go onto your brokerage account and enter buy and sell orders for stocks, you can go on an exchange, enter buy and sell orders for crypto, and fund it with a wire transfer or a credit card or with funds that you've transferred and deposited with that account. And then a couple moments later, you're the proud owner of a new cryptocurrency. Another way people are buying and selling cryptos directly is at these specialized crypto ATMs. A decade ago, there were only a few hundred of these across the world, most of which only allowed the buying and selling of Bitcoin. But over the last decade, really, they've been exploding in popularity. Today in the US, there are between 25,000 and 30,000 of these crypto ATMs, and they allow buying, selling, transferring, trading of all kinds of crypto, not just Bitcoin. Developing countries in particular, like Latin America, have seen explosive growth in the use of crypto ATMs, especially because they help international transfers. They remove a lot of the friction on those sorts of things. Another way people are directly owning cryptos is when new cryptos are minted in what are known as initial coin offerings or ICOs, similar to an initial public offering or an IPO of a company. Sometimes select investors get access to a coin before it goes public. And so this is another way where you might get access to a crypto in your portfolio. There are indirect ways to gain exposure to crypto that a lot of people are using. One way is that people are buying and selling companies, stocks, and exchange-traded funds whose values are pegged to cryptocurrency. So here we have an example of the Grayscale Bitcoin Investment Trust, which was one of the longer-running publicly traded assets whose value was pegged to the value of Bitcoin. Over the last year, we've had the approval of ETFs in the US for spot Bitcoin. And so you no longer have to deal with the issue of custody and keeping your private keys and passwords all secure. You can just invest in publicly traded companies who deal with all that for you, and you pay a slight premium as a result of the costs and other issues that are associated with that. There are other more advanced trades I'll flag briefly, not because they're advisable, but just so that you're aware that they're out there. Some exchanges allow for more advanced trading of crypto. For instance, they'll let you short Bitcoin or other cryptos. And since December 2017, people have also been able to invest in crypto futures. And so instead of trading on the value of what Bitcoin or other cryptos are today, you could trade based on what you think it'll be a month from now. Many exchanges also allow margin trading. Again, not advisable or prudent, but someone can invest and risk more crypto than they actually own to try to amplify their gains. And if their bet goes the wrong way, then their account gets liquidated in a margin call. I don't flag these because they're a good idea, merely to flag that they exist, and that to the extent a decedent dies with these kinds of assets, that will be something to clean up, of course. And while they're certainly less popular now than a year or two ago, I want to flag NFTs and confirm that they're still a thing. NFTs, or non-fungible tokens, are digital assets that are unique and hence non-fungible. Most cryptos are fungible. It doesn't matter which Bitcoin you have, they're all worth the same amount. But NFTs are different. By purchasing them, you're typically acquiring ownership of digital or other real-world items like art or trading cards like CryptoKitties. On the one hand, it seems crazy. Why would anyone pay any amount of money for an NFT of Jack Dorsey's first tweet when you can just go and take a screenshot of it for yourself and it's free? But on the other hand, I think people could make the same argument for famous paintings or trading cards or all sorts of other things that humans ascribe value to. Don't take my word for why people care. At one point, this is what the trading volume on OpenSea looked like. OpenSea is one of the world's largest NFT trading platforms. over the course of 2021, we saw explosive growth in the number of unique buyers on OpenSea. Some of this may have not been legitimate, of course, but then again, we also saw a precipitous drop-off in volume of NFT trades since 2021. We can see now that there's, an embarrassingly small amount of NFTs being traded. So maybe this is the example of POGs or, something that's been more of a fad than a long-term asset. But I would say that while NFTs themselves maybe aren't as popular as they used to be, maybe we're less likely to see them now, I think they are emblematic of the fact that digital assets are not just limited to cryptocurrencies. Cryptocurrencies are certainly the most popular, but there are other non-crypto assets out there that may find their way into estates over time, depending on, the whims of what the market says is popular or not. Okay, so before we move on, quick recap about how people are buying and selling. Certainly, direct buying and selling of cryptos remains the most common, but the number of investment vehicles by which one can indirectly invest in crypto are increasing. And lastly, advanced trades are available, less commonly used, sure, but they, may be gateways to massive losses. And so we want to make sure we check on those things. And lastly, NFTs and other non-crypto digital assets do exist, so we want to check for them. Okay, so we've talked about what blockchain and crypto are, how those investments might show up in the context of trust and estates. Now let's talk about some key estate planning and administration considerations. And I want to talk specifically about three things today: ensuring post-death access, safekeeping and custody, and of course, preparing for taxes. So starting first with ensuring access. Making sure that someone can obtain access to crypto is of paramount importance. That typically entails keeping track of usernames, passwords, accounts, wallets where they might be online, or if you have devices that are holding wallets, that as well. So as someone, if someone's preparing a will or a trust or otherwise preparing to pass on responsibility for crypto assets, they need to ensure that that successor fiduciary has access to all of those login details. Otherwise, they won't be able to get access to any of that stuff. There may be two-factor authentication involved. Depending on the transition involved, it could be complicated. Ideally, an estate planner is helping them out with those sorts of things, including by considering a grant of RUFADA rights to access digital accounts. It's sort of beyond the scope of today, but essentially you can grant your successor fiduciary rights with respect to accessing emails and authenticating things that might be helpful here. And then we need to make sure that we guard that information against unwanted eyes. If someone were to stumble across a document that had usernames, passwords, login information, account location, that's all they would need to loot those funds and potentially take them away forever. So if someone is smart, we're not just going to have the password of the keys to the kingdom in our desk. We would think about putting it somewhere like a fire safe or, in a safe deposit box. At the same time, we want to try to break up that information so that there's not one central point of failure. And we want to make that easy to update. We don't want to put it in a position where the fiduciary has to go through 100 steps just to get access to and update that information. It's vital that we think about this. And as the attorneys representing them, of course, we don't want access to any of this information. We don't want to have received a copy of the names and passwords and login information, because then if something happens to that account, we may be part of a small group of people who had access to the information that was needed to do that. And so it's not our job to get involved in handing off that information, but we, of course, do, as the attorneys, want to make sure that a process is in place by which that information can be transferred. Here's an example of how failing to ensure access can go horribly wrong. Several years ago, the CEO of one of Canada's biggest crypto exchanges, Quadriga CX, died at age 30 without providing anyone the password to the exchange's cold wallets of crypto. And that in turn caused more than $137 million worth of crypto to be lost irretrievably forever. I'm sure that number is far higher today based on what current values are. But suffice it to say that if an estate planner or a fiduciary were somehow responsible for that password log information being lost, the liability could be unimaginably high. So again, we don't want that information coming into our possession, but we do want to make sure that processes are in place for that to be transitioned to the successor. One way to help prevent access issues is by using multi-signature accounts, or M of N accounts. Most crypto transactions are single signature transactions, which means that you just need one person to enter one password or a private key to initiate or sign a crypto transaction. But many cryptos, including Bitcoin, support more complicated transactions than that, including ones that require signatures or private keys of multiple people before funds can be unlocked and moved. So these multi-sig wallets are a great way to ensure access. Maybe you do a 2 of 3 wallet. Maybe you do a 3 of 5 wallet where you have a larger number of people each receiving unique passwords. And that way, if something happens to one or two of them, you've got backup folks in place who, together with other trusted individuals, could still get access to that account. So for instance, if you had a 2 of 3 account, a multi-sig account that only needed 2 of 3 people to enter a password, you could conceivably have a husband, a wife, and their estate planner each take one of those 3 passwords. Again, we're not going to accept this as lawyers, but that would be a breakup. You could do it among 3 kids. If you have 2 children and 2 parents, you could do a 3 of 5 account where at least 2 survivors plus the estate planner or someone else, some other trusted individual needs to be involved. That way we don't have a single point of failure where someone with a password dies and crypto is lost irretrievably. Safekeeping and custody is a really big issue during administration. As we discussed a few moments ago, cold storage wallets are really common and probably a best practice. A cold storage wallet is an offline wallet that holds crypto funds. So with cold storage, the wallet is stored on a platform that doesn't have a hot internet connection, and that in turn prevents you from unwanted cyber attacks or hacks or other vulnerabilities from a system that is constantly connected to the internet. Hardware wallets are similar to a cold storage wallet, except the difference is you need to connect a piece of hardware and unlock it before you can access your account. Usually it's a thumb drive device like you can see on the screen here. This is a Trezor. It's a really common hardware wallet. You plug it into your computer, and in addition to logging in and using your private key or password to log in, you also separately need to unlock this device sort of in its own multi-signature account. It also needs to be unlocked for you to get access to those funds. Honestly, though, for large concentrations of crypto, which I know is the principal topic of today, I think you're probably going to want to look into using a professional crypto custodian. As the financial ecosystem has evolved in this space, it has evolved in the last few years, we've seen the emergence of professional custodians who use state-of-the-art security and best practices for cold storage and have all kinds of other features that they offer as well, step into this space and start to offer their resources to folks like we've seen with these ETFs, there's a huge amount of investment companies and other publicly traded companies that are now holding crypto. Professional custodians are stepping into that space. And at the same time, trusts and estates folks like us are having access to broader and broader suites of options for professional custody on the estate and trust level. So much lower than, BlackRock's investment funds, but we now have the ability as lawyers and fiduciaries of crypto estates to go out and get an honest to God professional handling this stuff. Whereas for a long time, our fiduciaries had to white knuckle it themselves in a way that was just not good from a risk management standpoint. So there's no bright line test. If you have this much crypto, you must go get a professional custodian. Below this amount, you shouldn't do it. But I would say that once you start having between the low and mid 6 figures in crypto assets under management, the peace of mind and the security that you'll get from using a professional custodian is probably worth that. As one example of how custody can go horribly wrong, I'd like to tell the story of the British IT engineer who in 2013 accidentally threw away an old computer hard drive that had a wallet on his desktop with about 7,500 Bitcoin on it. Today, that's approximately $877 million worth of Bitcoin that this guy just accidentally threw away. And so this poor guy has gone to the local city council multiple times, has petitioned, he's filed legal actions, trying to get permission to excavate the local landfill to try to find and recover this hard drive. He's proposed using all kinds of technologies to scan the landfill, but he continues to lose, and it doesn't look like there's any prospect of those funds being found. So suffice it to say that if a fiduciary is responsible for something like this, the financial exposure could be incredible. Another pitfall involves leaving one's crypto on an exchange. Leaving your crypto on an exchange is actually super risky because the funds there generally are not really in your control. They're actually held and managed and controlled by whatever exchange or company you've invested them with. The term in the crypto community is not your keys, not your crypto. If you need some other company to authorize your transaction, like Coinbase or someone else, that's not really crypto in your possession or custody. So imagine you're one of the users of Quadriga CX, that Canadian exchange where the CEO died without providing the password for over 137 million in crypto. If those funds disappeared, you might not be made whole from your deposits anymore. And the same thing happened in 2013 with Mt. Gox or Magic the Gathering Online. At one point, Magic the Gathering Online was doing 70% of all of the worldwide volume of Bitcoin trades, up until somebody realized at one point that approximately 650,000 Bitcoin had slowly been looted unknown to anyone from Magic the Gathering Online. And one day that was revealed, and that caused a multi-year crypto bear market. Suffice it to say, that's a perfect example of why we don't want to leave our assets on a crypto exchange, because not your keys, not your crypto, you could lose everything. Let's talk about taxes briefly, everyone's favorite topic. First, this should come as a surprise, hopefully to no one here, but you do have to pay taxes on your crypto. I've noticed it's really common for folks to think that because crypto has, anonymity or pseudonymity, where you can't really tell who it is that's transacting without doing a little bit of work, that means they don't ever have to pay taxes and no one's ever going to catch them. Don't let your clients be one of those people who think they can get away with it, because they probably won't. The clearest tax guidance we have on crypto from the IRS is in IRS Notice 2014-21, which is the starting point for any lawyer who wants to understand crypto taxes. And IRS Notice 2014-21 clarifies that for tax purposes, digital currencies like cryptos are property, not currency. So that means the familiar short and long-term gain rules apply to purchases and sales of crypto. Let's take a quick hypothetical. Your client buys a Bitcoin, holds it for 364 days, and then sells it. Because they held that Bitcoin for less than a year, they would owe short-term capital gains taxes on any increase in value. So if the Bitcoin grew in value from $1,000 to $2,500 over those 364 days, your client would owe short-term capital gains taxes on that $1,500 increase. On the other hand, if your client held that Bitcoin for more than a year before selling it, they would owe long-term capital gains taxes on that $1,500 increase in value. Another thing we learned from IRS Notice 2014-21 is that all crypto transactions are taxable events. So it's not just when you buy and sell crypto or when you sell crypto for US dollars that are taxable events. Even if you go to a coffee shop and they let you, swipe your Bitcoin wallet and use Bitcoin to pay for a coffee, that is a taxable event. It is as if you sold that Bitcoin for US dollars and then used those US dollars to buy that coffee. You owe whatever the capital gains taxes are on the increase in value of that Bitcoin that was sold for the US dollars to buy that coffee. So very aggressive in terms of all transactions being taxable events. Don't be people, you don't want your clients to be the folks who think trading cryptos aren't taxable events or this isn't a taxable event. Odds are everything is a taxable event when it comes to crypto transactions. In 2019, the IRS released additional guidance in IRS Notice 2019-24. Among other things, Notice 2019-24 clarified that FIFO is the standard default basis way for calculating basis in crypto. FIFO being first in, first out. Unless a taxpayer can specifically identify and can prove what the tax basis was for a specific crypto sold. So let's take a hypothetical and see how that would rear its head. Let's say your client buys a Bitcoin 2 years ago for $10,000. And then yesterday they buy a second Bitcoin for $120,000. And then tomorrow they sell one Bitcoin for $130,000. How much in taxes would they owe? Under 2019-24's guidance, FIFO controls first in, first out, and the default presumption is that you sold the first one you bought 2 years ago, And so the basis for that would be $10,000, and you would owe taxes on the $120,000 gain from $10,000 to $130,000. On the other hand, if you can show that the Bitcoin you sold tomorrow was actually the one you bought yesterday, you would owe $120,000. That would be your tax basis, and you would only owe the $10,000, the taxes on the $10,000 gain. So this does have the potential, this method of calculating basis has potentially huge ramifications on tax bills that are ultimately calculated. And under 2019-24, you have to use FIFO unless the taxpayer can specifically identify. IRS Notice 2019-24 confirmed a few other things that are sort of more bespoke, but which may affect your particular holdings, including how hard forks are taxable events, but soft forks aren't. Rules about deducting charitable contributions. I won't get lost in the weeds in that, but definitely important to look at if those are things coming across your desk. Lastly, I want to flag a really interesting IRS revenue procedure ruling that came out last year, caused a lot of chaos, only to end up having its implementation effectively deferred for a year until the end of this year. So in short, IRS revenue procedure 2014-28 did a couple things. First, it confirmed that tax basis must not only be calculated using FIFO as a default rule, but must be calculated on a wallet by wallet basis. So what that means is that, before, what was commonly done is taxpayers essentially aggregated all the crypto that they bought and then divided the basis evenly among them. And so if you owned one Bitcoin that cost you $100,000 and another Bitcoin that cost you $50,000, then you sold a Bitcoin, you could combine those bases and say that the one you sold is half of that combined basis. But under this new revenue procedure from 24-28, you no longer are able to do that. Instead, you have to look at the actual basis of the crypto in that wallet and then determine what the cost basis is from that. This was devastating for lots of taxpayers, and it caused such an uproar that they essentially immediately came out with guidance saying that this no longer is going into effect until the end of this year. The other thing that the IRS Revenue Procedure 2024-28 did is it created a safe harbor procedure. So because this was causing such a significant change in the way taxes were done, the IRS allows people to make a one-time allocation of basis among all of the crypto that's in their possession as of a certain snapshot in time. The snapshot in time was originally as of the end of last year. That snapshot in time has been extended basically to the end of this year under a subsequent revenue procedure. But essentially, you have one last chance to take advantage of the way the rules used to be. And then from that point forward, we are going to be in this land where basis is not only going to be default FIFO, but also on an account by account or wallet by wallet basis. Let's talk briefly about best practices for taxes. First and foremost, please make sure the fiduciaries are keeping good records of all crypto transactions. Thankfully, we have a lot of API-based services now that can plug in directly to Coinbase or all of these other wallets and pull transaction data, calculate what your taxes are, and give you a pretty good estimate for a lot of this. But that's not necessarily always the case, depending on which exchanges or wallets are being used. So you can't always bank on them. And just for your own purposes, you probably want to have backup records. And so I would recommend keeping track anytime crypto assets are sold or transferred, the date, the time, the exchange, the price in crypto and fiat, fees. These are all things that are going to feed into the tax calculations at the end of the year. And you can use the API-based automatic stuff to double check your work, but I would want to have that as well. Another thing we want to do is monitor taxable gains and losses throughout the year so that we're not caught, flat-footed in tax season. We'll talk in a moment about how that can go wrong, but we want to keep an eye on that. We don't want to have no idea what our taxes are going to be until the new year has started, when we no longer have a chance to mitigate it. And then, of course, we want to make sure that we're in constant contact with our tax professional. And not only that, but our tax professional is competent and fluent in cryptocurrencies. There are a ton of great tax folks out there who just have not had a chance to really become experts on the crypto space yet. And so they have to learn a lot of this stuff on the fly. If you're in a situation where you've got a large concentration of trust or estate crypto, I think you want to spend the extra money to go out and find someone who's fluent in this stuff and knows how to calculate these transactions, knows which forms to populate, knows what kind of backup information, knows what kind of audit questions they might get. I think they are going to be easily worth the extra effort there. Now, in terms of how this can go wrong, I like to point back to what happened in December 2017. At that time, that was when Bitcoin's value jumped up to $20,000 for the first time. And the run up to it was insane. It was every single person who threw money at Bitcoin was making money at this time. And so people kept investing and investing. And then all of a sudden in January 2018, the prices of Bitcoin plummeted. But at that point, all of the prior year's transactions and taxable gains had accrued. And so people all of a sudden owed enormous tax bills in April 2018, but the crypto market had fallen so much that their assets weren't even worth all of the taxes that they owed. And so a ton of people had to sell everything, had to realize enormous losses just to pay taxes from all of these transactions that were happening when the market was great. And so, maybe they should have realized some gains, set aside some funds to make sure that they had funds set aside to pay tax bills in the next year. These are the kinds of reasons why you want to make sure that you're keeping an eye on what the taxable gains are going to be for next year. Again, if a fiduciary is responsible for something like this, it could be enormous liability. So we don't want to let that happen to our fiduciaries. There are a number of other crypto-specific administration issues that might come up. We don't have time to cover all of them today. Many of these were mentioned in the Estate of Mellon filings, though, and I thought they were interesting, so I at least wanted to put them on your radar, just to give you a sense of the kind of messes that you could be called in to clean up if there's a large concentration of crypto in a trust or estate. Okay, last substantive topic of the day, and that's fiduciary duties. We will talk about investment duties in a moment, but starting first with general fiduciary duties, we know that trustees must first and foremost administer the trust according to its terms. They must also act with reasonable care, skill, and caution that a prudent trustee would use. If an expert is involved, they're going to be held to a higher standard. This is basic boilerplate stuff. But what about when we get into the Uniform Prudent Investor Act? There we've got some heightened duties. Again, we're looking at the reasonably prudent investor standard, but there are certain specific burdens that we take on in managing investments. The trustee must evaluate decisions about investments, not just in isolation, but looking broadly at the overall portfolio. They have to look not only at their own investment decisions, but they need to look at inception assets, investments that were made by the prior trustee or whoever was in charge of these assets. And while they can delegate some of these investment functions, they remain responsible for the performance of these assets if they're not properly overseeing them. So what does that entail here? We have to gather information about specific factors set forth in the probate code, things like purposes, terms, distribution requirements, and circumstances of the trust. And there's 8 other factors, of course, that the UPA requires us to look at and gather information about in making investment decisions. Those things include general economic conditions, effective inflation or deflation, potential tax consequences, some additional items as well here. And so, by statute, trustees are supposed to be looking at all of these factors and trying to navigate how they might align with the underlying investment portfolio. And where the underlying assets don't align with these factors, they should be thinking about how to change those investments so that they do. What are some best practices in this standpoint? Number one, we have to not only gather that information or make sure that whoever our delegee is gathering that information, but also documenting that information. And we'll get to a moment in diversifying. So, again, gathering information about blockchain and crypto investments isn't easy. There's a lot of them out there, and all of them look really enticing. The true fact is that most of them are probably scams. Even if they're not outright Ponzi schemes or money laundering enterprises, most cryptos have virtually no benefits over those that are already in existence. They're just a cash grab. They're the equivalent of pets.com during the dot-com bubble. And so, we do need to do our research on this and not just take people at their word when they say this is going to be the next new Bitcoin. This is super Bitcoin. You're going to be 10 times richer than if you'd held Bitcoin here. In doing that research, got to document it here. We don't want to be in the position of having to reconstruct supporting investment analysis after the fact. And especially in a place like crypto, where assets are extremely volatile and risky, and where there's just so much fraud and mismanagement by underlying crypto projects, this is a place where you almost can't put too much effort in. So I would say not only does a fiduciary want to have data compiled in a report that they're reviewing and deciding how to handle a crypto investment, but a lot of times, especially with large concentrations, they're going to want to check in with the beneficiaries about that. If you have a situation where a settlor dies with a huge portfolio of trust assets, the trustee may not want to take on the risk of keeping those assets largely overinvested in crypto, but maybe the beneficiaries will want that. I think that's a perfect situation where a report from an investment advisor can set forth the potential risks. Sure, there's some benefits, but here are all the risks. Here's why the trustee doesn't think that it's prudent to keep all these assets invested in crypto. Again, I think the more writing and paper you have, whether you share it with the beneficiaries or not, is going to bolster your defense if someone later tries to say that there was an imprudent allocation of crypto. The third and final practice I want to flag here is diversification. We need to make sure that crypto assets are diversified. We have to insist on it. And again, there's a lot of folks who, people who are investing in cryptocurrencies aren't always the most prudent investors. They're not, carefully allocating investments in a way that's, up to what the standards might be. But if successor fiduciary doesn't have that luxury, if you're a trustee coming in, it doesn't matter if your settlor made a bunch of really risky bets on crypto and thought that was great. If you're called in to manage those assets, you need to start thinking about what's prudent. And if the inception assets, the existing assets, when they come in aren't prudent, you need to think about diversifying. And so, one of the big problems we face in diversification with crypto is that, essentially, it's really difficult to get a properly diversified portfolio of crypto because they're all so correlated with one another. Under investment theory, we want assets that have a low or negative correlation so that if one asset goes down, it doesn't tank all your other assets. Maybe they go up or maybe they stay unchanged. But with crypto, they're all so correlated with one another that it's really difficult, if not impossible, to construct a properly diversified portfolio where crypto makes up a huge portion of it. Excuse me. So what do these high correlations suggest for a hypothetical prudent investor? I can think of at least 4 things. Number 1, proper diversification for most trusts is going to require a portfolio that is balanced with lots of non-crypto holdings, especially assets that don't suffer from some of the same issues that cryptos do. High volatility, high incidence of scams and fraud, very little in terms of distributions over time. And so we would try to counterbalance a portfolio with a lot of crypto with things like maybe treasury bills or income and dividend paying stocks and bonds, low risks ETFs and the like. But the more risk we take on with an overbalanced crypto portfolio, the more we're going to want to try to counterbalance that. Second, in light of the hacks to individual cryptos and exchanges, a prudent investor is going to want to spread their assets across multiple crypto assets and platforms. That way, they're limiting the risk of any single asset or platform being the target of a devastating hack like Bitcoin was with Mt. Gox. If you're spreading your crypto among other assets or platforms, you may be less susceptible to the diversifiable risk there. Oh, sorry. Getting ahead of myself. Number 3, it's easy to be allured by advertisements inviting you to lend or stake your crypto for a regular return on your investment. Some companies offer rates as high as 5 to 10% annually for staking your crypto with them, depending on which coins and the term and the period of time involved. But if one of those companies gets hacked or makes a bunch of bad investment bets or, has a bunch of schemers and pyramid schemers and scammers involved, you as an investor could lose all of your asset just because you were chasing a couple percent in yield. So while I think a prudent investor might think about some amount of income generation from your crypto, I think that they're also probably gonna diversify across multiple assets, but then also leave a significant amount outside of the staking realm because they don't want to lose all of that. You want to protect the bulk of your assets from being lost to those kinds of risks. Fourth, and finally, a prudent investor that wants to gain access or exposure to the blockchain and crypto markets, There's a lot of ways to do it that don't involve directly buying and selling crypto. You can invest in companies that build hardware or peripherals for miners, or energy companies, because we know that the energy needs involved for these kinds of technologies are enormous. Those are ways where if you're a crypto believer, you can gain access to it without necessarily needing to buy and sell and hold and manage and administer crypto, which for a lot of people is just over their head. And sort of the last big thing I want to flag here is key tools for trustees and their counsel. I mentioned this earlier, but RUFADA, the Revised Uniform Fiduciary Access to Digital Assets Act, is the main set of statutes that in California under our probate code, and nationwide, really every state uses RUFADA. This is the set of statutes that we would use to gain access to a decedent's crypto accounts after they've passed away. Essentially, a trustee or a fiduciary responsible for marshaling the assets would send a written request to Coinbase or Kraken or whatever third-party entity is holding crypto or other digital assets of a decedent. Some information would need to be provided, like a death certificate, letters of appointment, etc. But once you go through that process under RUFADA, a successor trustee or fiduciary is required to be given access to whatever digital assets that were held by the decedent. The one exception is for emails, contents of emails. It's not quite as straightforward. There's a little bit more involved. But for digital assets, Bitcoin, cryptocurrencies, that sort of thing, a successor fiduciary can basically always get access to those things under RUFADA. Probate Code Section 850 or Hegstad petitions. As we know, this is a really common way in California for us to get assets that are outside of a trust deemed to be within a trust. You can use these to retitle crypto accounts and assets that up until now were really difficult. It's very hard to open an account in the name of the trust on Coinbase or Kraken or something like that. And so for a lot of users, really the only way to get those titled in the name of a trust was after the fact using an 850 or Hegstad petition. I've done this successfully. Cold storage wallets, you'll want to make sure you're using that kind of thing, or a professional custodian for large concentrations of crypto. I mentioned the crypto tax software, the API-based stuff that you can have pulled data for trades directly from Coinbase and whatever else you might be using that can help your fiduciaries and your accountants in figuring out what taxable gains or losses might be and keeping track of that throughout the year. And then finally, I've got who doesn't like being linked to the IRS homepage here, but I've got a link to the IRS page here specifically on crypto and digital assets. I know it says small businesses there, but this is a compendium of really all of the official guidance, publications, frequently asked questions, and other resources from the IRS as to crypto and digital assets. So it's great for you as a taxpayer. It's great for whoever's going to be handling the taxes for that. It's a one-stop shop for anyone who wants to see what the complete IRS guidance is on that. And with that, we've covered all of the substantive sections from today's talk. In closing, I want to reiterate that it's been an honor to get to speak with you all today. Happy to stick around, do my best to answer some questions. If we can't answer them all, I'm happy to follow up on them after the fact. And I guess the last thing I'd say is if you enjoyed today's talk, please consider finding me on LinkedIn and endorsing me. And here's where you can do that. This time it's actually on the screen. So with that, any questions?
Teal, we actually can't hear you.
There we go. Sorry. Can you hear me now?
We can hear you now.
Perfect. Thank you. We have a couple questions. If you have a couple minutes, I think these would be, I don't think they're going to be super intensive, and I think they would be beneficial. So the first one is, can cryptocurrencies be used to fund a living trust?
Yes.
Perfect. The next one is, will crypto get a step up in basis for the heir when owner passes away?
Ooh, that's a great question. Not something I've come across yet, but I'd be happy to look into that and circle back with folks.
Okay, perfect. And then last one, what are the provisions for tracing or otherwise trying to recover digital assets lost if a client was the victim of a bad decision, or recovery from a pump and dump scam?
Yeah, really common. There's just so much fraud and scams rife in this area. I will say that there's a couple different things that are at your disposal. Number one, for a lot of crypto transactions, the types of crypto, they are upon public databases. So if this involved Bitcoin, you can go and look at what the current, list of every transaction that's ever happened. There are companies out there that can work with you forensically to follow up on specific transactions. It's not necessarily going to have the name of the person who, engaged in that transaction, but with really stunning accuracy, there are companies that can reverse engineer who these people are and then say where their wallets go. You might be able to use that to subpoena a financial institution if you can see the wallets are being, transferred. Eventually, those funds are transferred to a Coinbase account or a Kraken account. There are ways you can look at the public database of transactions to try to do that. And then furthermore, the other tool I'd say is going back to my slide a moment ago is under RUFADA, the Revised Uniform Fiduciary Access to Digital Assets Act, you can request from custodians of digital assets information about emails that you've sent. A really long-winded way of saying, I've had a decedent die. I sent a request to Hotmail. This is a case that's over for years now, but decedent died. We were afraid that he had been subjected to undue influence and fraud right before his death. And we sent an email, we sent a request for RUFADA to Hotmail, which had his emails, and we got a list of not the contents of emails, but folks' names who had been sending him emails. And we saw emails from a major crypto company. We had no idea that crypto was on this guy's radar, but from that, we were able to reverse engineer. He was in talks with crypto, and we were able to use that to find several cryptocurrency assets that had previously not been known to us and recover those for the estate. So I'd say, use a forensic person with publicly available trade data, and then you might also have a backdoor by using RUFADA in a certain way. I've had success doing that anyway.
Perfect. That's super helpful. And I think that's all the questions that we have. So thank you so much for your time today. I know that was really interesting to me, and I'm sure our members got a lot of value out of it too. I learned a ton. So that concludes today's program. Thank you so much, JD, for your time and an excellent presentation. Our next program will be regarding short form versus full form settlement agreements and trust and estates litigation. This program will take place on August 19th with Michael Brophy. Thanks for joining us this afternoon, and everyone have a great day.
Thanks. Bye now.